If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. Did you know that if you win a copyright lawsuit, you could get reimbursed for your legal fees? Today, we are talking about the finances behind copyright litigation and how you might be able to get your money back after you've gone through a lawsuit. If you are new here, hi, welcome. My name is Christian Hammond. I'm a licensed attorney based in Washington, D.C., but serving clients worldwide. And I specialize in trademarks, copyrights, and helping businesses, especially small businesses, get legally protected. And like I said, today we're going to be talking about the finances behind copyright litigation. So I definitely suggest grabbing a notebook, grabbing a pen, grabbing whatever you would like to use to take notes, because this is going to be jam-packed full of very useful and also very practical information for anyone, regardless of which side of the equation you might be on. Whether you are someone who your business depends on amazing original products and content, and you've seen that being copied by others, or whether you have been accused, of copying other people's work, regardless of which side you might be on this equation, this episode is going to be super useful for you. And today's episode was inspired by a recent lawsuit that happened in Texas. And to quickly summarize what happened, this was a lawsuit between an artist and an art studio. And what happened is that the art studio, during the height of the pandemic, decided to start selling art kits. And they would choose artists. Some were well-known and famous, others were more up and coming, but they would pick an artist, and each kit would have that artist's biography. It would have an example of their work, and then it would have materials, and these were marketed to children. So it would have materials that the children could then use to create their own artwork in the style of that artist. And if you bought one of the kits, you could also sign up for a Zoom class, and that Zoom class would teach you about the artist, teach you about their artistic style, and also teach you how to use the materials in the kit to create art in the style of that artist. Now, some artists who were featured in these kits loved it and thought it was great, but there was one artist who did not think so. She did not appreciate her work being used. She did not appreciate her work being used without her permission, so she brought a copyright lawsuit. Now, what's important to know to understand why things turned out in this lawsuit the way they did is that the art studio only sold 6 kits with featuring this artist. Really, they only sold 4 because 2 of those sales were actually made to the artist's lawyers in preparation for the lawsuit. As a sidebar, this is very, very common. So, as a lawyer, if a client comes to you and they say, hey, someone's copying my product, someone is selling counterfeits, somehow they've got the design, they've got the diagram, they have the recipe, for my product and they're selling it. Well, if I'm a lawyer and I'm going to bring that lawsuit, one of the things that I'm going to do is I'm going to purchase one of those counterfeit products. And then that becomes evidence in the lawsuit. It shows that the product is counterfeit. It shows clearly that they were selling the counterfeit and by being able to obtain it, it shows that they were willing to be selling those counterfeits. And so very common legal strategy. And so that's why 2 of the kits were actually bought by the artist's lawyers. They bought those kits knowing that they were going to use them as evidence. But that means that they really only sold 4 of the kits. But even if you count all 6 art kits that were sold that featured the work of this artist, they added up to a grand total of $240. So basically, the art studio made $240 by selling the art kits featuring this artist. Well, the artist, when she brought the lawsuit, was claiming damages of up to $900,000. So $240 in actual sales versus $900,000, up to $900,000 in claimed potential damages. Well, the court took issue with this. They did not like this at all. First, they ruled against the artist. They ruled that these art kits were actually fair use. Now, I recently wrote a blog post on fair use. It's on my website. Go to www.bevellaw.com, go to resources, go to help articles. The blog post is right there. So I covered fair use in that recent blog post, so I'm not going to do a deep dive on it in this episode. But what's important to know is that the court looked at the case and decided, actually, the way they used the work in the context of these art kits was actually fair use, which meant that the artist lost the lawsuit. She lost her claim for copyright infringement. But not only did the court rule against the artist, but they also found that her claims were unreasonable. And because her claims were unreasonable, they ordered her to pay the other side's legal fees. And that was over $100,000. So not only did she lose, she also had to pay the legal fees for the person that she sued. She had to reimburse them for what they had to pay their lawyers and what they had to pay court cost-wise. So why does this matter? I think that it's really important to understand why this ended this way and what it means for you, again, regardless of which side you might be on the equation, whether you are a business owner watching other people copy you, or whether you are facing an accusation or a claim that you have copied another business. It's important to understand why this case happened this way and what it means for you when you are weighing the financial pros and cons of getting into a copyright lawsuit. And that's what we're digging into today. Because I think that for business owners, and especially for small business owners, the cost of litigation is often a big barrier to people bringing rightful, totally legitimate lawsuits. They have been wronged. The contract has been breached. They have been screwed over by their business partner, manufacturer, vendor, etc. Right? Like these things really have happened, but oftentimes the barrier to bringing that lawsuit, to having your day in court, to getting justice is the financial aspect of what it would mean to bring a copyright lawsuit, what it would mean to really go the distance in court asserting your legal rights. And so I think this is a super important topic, a super important question, and that's why we are talking about it today. Now, you might be surprised to hear that the idea that you would pay, that you would be on the hook to pay your legal fees, regardless of whether you won or lost, is actually a uniquely American idea. That is actually not how things work throughout the world. That is not how things work if you lived somewhere else and maybe brought a lawsuit somewhere else. So, here in the US, we have what's called the American rule. And the American rule says that when two businesses, well, it could be anybody, but this is a business podcast, so we're talking about business. When two businesses go to court, when, regardless of who wins or who loses, they have to pay their own legal fees. You hire your lawyer, you agree to pay them whatever you're going to pay them. The other side hires their lawyer, they agree to whatever fee agreement. And regardless of who wins or loses at the end, each side has to bear the weight of their own legal costs. Each side has to pay their own legal fees, whatever that might cost, to have their day in court and to be able to bring that lawsuit. It might surprise you to know that that is not true everywhere. And the contrast is the British rule. And the British rule is that when there's a lawsuit, it's actually the losing party. The losing party has to pay the legal fees for the person who won or for the business who won. Now, that means that as a business, you still have to come out of pocket, at least initially. You have to come out of pocket initially to pay for litigation. But at the end, if you win, the other side is going to have to reimburse you. The other side is going to have to pay you for your trouble. The other side is going to be on the hook for both bills. So that's the difference between the British rule or the English rule and the American rule. Now, since we are here in the US and we are bearing the burdens of our own litigation, in my mind, for normal, rational business people, there's really only three things would have to be true for you to be willing to bring a lawsuit. One, you would need to be suing for more than you expect to pay. So if you plan to spend $20,000 on litigation, you would want to be suing for, maybe $40,000, right? So you would want to be in a situation where you stand to gain. You are suing for more than you plan to spend bringing the lawsuit, right? Because that's the only way to make it worth it. So that's one thing that I think would have to be true if you are a rational, normal business owner thinking about litigation. That's one option. Option two is if you are suing for your rights, your dignity, your reputation. And this recent example I'm thinking of is Gwyneth Paltrow. She was sued in a skiing incident. Somebody sued her and said, hey, she was skiing in a way that was, I'm not sure whether the case was reckless or negligent, and doesn't matter for our purposes, but they sued her because of a skiing accident. And Gwyneth Paltrow countersued for $1. Now, when you sue someone for $1, you're making a statement and you're saying, it's not about the money. I'm suing for my reputation. I'm suing for my honor. I'm suing to prove that I am innocent. And Gwyneth Paltrow, maintained the whole time that she was innocent, that she was not responsible for that skiing accident. And the jury ultimately did rule in her favor. So that's another option. Maybe you're suing for your honor. You're suing for your reputation. You are suing to prove that you or your business are innocent of the claims that are being brought against you. And then the third option is if there's some underlying maybe social or civil rights issue kind of under the lawsuit that you truly care about. So maybe, the lawsuit is whatever it is, but there's an underlying environmental discrimination, racism, harassment. Like there's some social issue or maybe some civil rights issue kind of undergirding that lawsuit, and you care about that. And so you don't care about the cost. Maybe you're willing to come out of pocket for that lawsuit, or maybe you're able to find a lawsuit that will actually represent you pro bono. But in my mind, because we're under the American rule, because as business owners, win or lose, we're going to end up paying those litigation costs anyway. Typically, one of those three things has to be true for it to really be worth it for us as business owners to bring that lawsuit. Either we're suing for more, than we're going to have to spend, or we're suing for our honor or our reputation, or we're suing because there's a social issue or a civil rights issue, that's kind of part of that case, and we care about it so much that it's worth it, it's priceless, and we're willing to go forward with it, right? And so this is a problem. The cost of litigation and the incentives that it sets up for us is a problem when it comes to copyright law. Because the expense of litigation and the reality of, having to pay for it win or lose means that even if someone has legitimately copied you, even if you have legitimately been wronged in a copyright context, you still might not bring that case. You might not do anything about it because you might decide it's not worth the financial cost. And so that person's just going to get away with it. Copyrights are not being protected because, people are deciding it's not worth it. And that's a problem. And so that's a problem, but the flip side is also a problem. If you have actually done nothing wrong, but somebody else is accusing you of copyright infringement, somebody else is accusing you of copying, well, you might just roll over and pay the settlement because paying the settlement is cheaper than going to court. And so both of those situations are a problem. If you've your business has been harmed, your business has been ripped off, your business has been counterfeited, other people are copying you, but you don't do anything about it because it's too expensive. Or somebody else is basically, holding you for ransom, accusing your business of something that your business did not do, but you're rolling over and paying the settlement anyway because that's cheaper than litigation. Those are problems. And Congress foresaw that that would be a problem. And because Congress foresaw that that would be a problem when it came to copyright law, they passed a law to deal with that. They passed a law to address that issue. So even though normally, under normal circumstances in American litigation, win or lose, each party has to pay their own legal costs. It doesn't matter if you won or lost. That's actually not the case when it comes to copyright litigation, because there's a special law in the Copyright Act. And what that law says is that if there's a copyright lawsuit and if the party who lost was being unreasonable, if they brought the lawsuit in bad faith, if that lawsuit was frivolous, or if there are, just other reasons that would be there are other reasons that reimbursing the other party would be important for honoring the original intent of the Copyright Act, the court can actually choose to reimburse you. In other words, if you get into a copyright lawsuit, regardless of which side you're on, and the other side is any of those things, they're being unreasonable, they've brought this lawsuit in bad faith, this is a frivolous lawsuit, or, you are not made whole, financially whole by the end of the lawsuit, or they would be getting away with doing something bad by the end of the lawsuit, the court can actually choose, instead of the American rule, they can choose to apply the British rule. They can choose to order the other side to reimburse you for your legal fees and costs. And that is meant to fix this problem. It's meant to fix the problem of people either not bringing lawsuits when they should because they're afraid of the cost, or people just kind of folding and giving into bad settlement deals because that's cheaper than seeing the litigation all the way through. So this is a special exception. Again, this is not true for all American litigation, but this is a special exception in copyright law, and it's meant to protect people from lawsuits that are, again, lawsuits that are frivolous, lawsuits that are unreasonable, lawsuits that are being brought in bad faith with bad motivation. It's meant to protect people from that problem. And you might be wondering, why was it necessary for Congress to pass a special law just in the area of copyright? Like, why was it necessary for them to pass a special law just in this area? Well, I think there's more than one reason, but the reason I want to talk about today, because I think it's salient and relevant for business owners everywhere, is because copyright lawsuits can attract the crazies. Copyright lawsuits have a tendency, or maybe even a heightened tendency, to attract the crazies, to attract the ridiculous, to attract the overreachers, to attract unreasonable litigants who should not be bringing cases. And I think the big reason that this is true is because copyright lawsuits potentially, if you win a copyright lawsuit, you potentially stand to get a lot of money. And that's because of, again, how the Copyright Act is written. So normally, if you bring a lawsuit, if you sue somebody, you can't just sue for any amount of money that suits your preference. You actually have to come up with a reasonable number under the circumstances. And I know that this is not what you have seen on TV. This is not what you've seen in movies. There's always that in TV and movies, there's always some ridiculous character who's suing somebody for $10 million because they looked at them funny, right? So popular culture makes it seem like you can sue anybody for anything for any amount of money. But that is actually not true in the real world. So in real world litigation, you have to have a basis. You have to have a reason for the amount of money that you are suing for. So if your manufacturer screwed you over and that resulted in you losing 10,000 units of product that you would have otherwise sold, well, then when you go to sue them, then you say, okay, the manufacturer breached the contract. That cost me 10,000 units of product. Here's how much that 10,000 units of product was worth. Therefore, that's how much I'm suing for, right? So there's a reasoned calculation. There's a concrete calculation that goes into deciding how much to sue for. Copyright law is different because copyright law allows for what's called statutory damages. Statutory damages just means that there is an actual dollar amount in the law, and you don't have to prove that dollar amount the way you normally would have to in other lawsuits. So the Copyright Act actually has some pretty steep statutory damages. In other words, if you win a copyright lawsuit, you can potentially win a ton of money. And those statutory damages within copyright are anywhere from $750 to $30,000 per infringement. So if somebody sold 10,000 counterfeit units times $30,000 per unit, that's potentially a lot of money. That's a kind of a, incredibly, worst case scenario, maybe copyright situation, but you get the point. You can do the math and realize that, hey, you could actually, if you win a copyright lawsuit, you could potentially get a lot of money. And that's under normal circumstances, $750 to $30,000 per infringement. But in exceptional circumstances, specifically if the other side willfully infringed, if the copyright violation was willful, that dollar amount goes all the way up to $150,000. So this is great if you are a legitimate copyright plaintiff. If you've legitimately been wronged, someone has violated your copyrights, especially if they've done it on purpose. You've got a serious counterfeiter out there. You maybe have a disgruntled employee who stole some intellectual property on their way out the door. You have a business partner who signed an NDA and signed a severance agreement, but they're not honoring that. They've taken your ideas and they've started a competing company. There's many different situations where you could be, you would be a fully justified copyright plaintiff. And in that case, this is awesome. It's awesome that the law has provided a way for your business to be compensated for the things it has lost. But as always happens, because there's this potential to win a lot of money, copyright lawsuits also attract the crazies. And because copyright lawsuits attract the crazies, that's why, or that's, I would say, one of the reasons why Congress passed this law that allows you, again, if you end up in a copyright lawsuit, facing off against an opponent that is unreasonable, motivated by bad faith, or the lawsuit itself is actually frivolous. There's no basis in real law or fact for the lawsuit. Congress has provided this way where courts can actually decide to force them to reimburse you. And courts don't have to reimburse you, but they have the discretion to choose to reimburse you in those situations. And you have the opportunity to petition for the court to force the other side to pay your legal fees in those situations. All right. And so we've been talking kind of a lot, assuming, that your perspective would be the victim, for lack of a better term. You are the victim of a frivolous lawsuit. You are the victim of an unreasonable lawsuit. You are the victim of somebody trying to shake you down for money that they are not actually entitled to. And that's really the perspective we've been taking. And I just want to end by quickly talking about the flip side. I don't think we can ignore the flip side. And the flip side is considering, is it you? Are you the person? Are you the one? Are you the person potentially bringing a lawsuit that might be frivolous, that might be unreasonable, or that might be motivated by bad faith? And I want to talk about this, and I think it's important to talk about this because if your business has been wronged, that's really personal. Especially, I think, as a small business owner, if the thing that you have been pouring your heart and your soul and your blood, your sweat, your tears, your sleepless nights, your own money into has been wronged, copied. You see your products being sold somewhere that you did not authorize them to be sold. You see your ideas being marketed somewhere that you did not authorize them to be marketed. That's really personal, and that really hurts. And I think that is justified. Like, you are justified to be angry. You are justified to be upset, right? I mean, who wouldn't be? But I think there's a tricky thing that happens in these situations. And I want to be really clear that I'm all about having your day in court, when you deserve your day in court. I'm all about it. I'm a lawyer. I am all about enforcing your legal rights, fighting for your legal rights, hiring someone to fiercely, strongly, passionately advocate for your legal rights. I'm all about that. But what I will say, and what I have seen as an attorney, is that in my experience, business litigation is often very personal. I'll say that again. Business litigation is often very personal. The overwhelming majority of business lawsuits or business disputes settle outside of court. They are worked out over negotiation tables. They are worked out by the attorneys. They're worked out sometimes amongst the CEOs or the other executives, but they are worked out outside of court. The vast majority, the overwhelming majority. And so when businesses go to court, when there is a commercial dispute, I find my experience is there is often a personal component to it. personal beef, there's not always, but there's often a personal component to it. And I think as business owners, what we have to stop and ask ourselves is, okay, I'm feeling these things. I'm going through this. This is happening to me. This is happening to my business. But is this lawsuit that I'm about to bring, is it rational? Is it reasonable? Is it the best thing for my company? And, so often people come to me and they're like, oh, I need a lawyer who's a pit bull. I need a pit bull of a lawyer. And I gotta ask, do you? Do you? Is aggression the only way to accomplish your goal? And I think that, again, I think this is something that pop culture and movies and TV have kind of skewed our view on and kind of made us think that aggression and table pounding is the only way to get stuff done. It's the only way to get what you want. And I don't know about you, but, for me, especially as a lawyer, if someone shows me that they have the ability to be reasonable, I am much more likely to work with that person. I am much more likely to work with them if they show me they have the ability to be reasonable. Whereas if they show up acting crazy, talking sideways, if they convince me that fire is the only language they understand, it is very unlikely that I'm going to give even an inch, right? It's just kind of human nature. And so I just want to kind of close out this episode with that thought. When we feel wrong, when we feel hurt, when we feel like there is an assault against our business, I think all of those emotions are really natural. But I think that as CEOs, we have to take that step back and think, is this rational? Is this reasonable? Is this the best thing for the company? And to take that decision with wise counsel, with working with an attorney who can help you understand what is the breadth and what are the limits, what can we do, what shouldn't we do, and what makes sense for the company. And again, realizing that aggression is not the only way to get things done. It's not the only way to get what you want. And frankly, it's not always the best negotiating strategy to be able to get that goal. All right. So that is all that I have for you guys today. I am so grateful, as always, that you joined. So grateful for your presence. Thanks for listening. Thanks for watching. And I will see you next time. Bye. Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.